Most people arrested during a routine traffic stop were not pulled over for anything serious. They were pulled over for a tail light, a rolling stop, going 8 miles over. And then they said 3 words, 3 completely ordinary words that handed the officer exactly what he needed to make an arrest legal. This video is about those 3 words, why saying them is the single most damaging thing you can do at a traffic stop, and what you should say instead that keeps you protected every single time. Stay with me through this, because the part most people skip is the part that actually gets them. Before we go any further, if you are watching this because you want real, practical legal knowledge that you can actually use before something happens to you, not after, subscribe right now. Every week on this channel, we cover exactly these situations. What to say, what not to say, and what the law actually requires from you versus what officers are counting on you not to know. Here is where this starts. You are driving home on a Thursday night on I-285 outside Atlanta, Georgia. It is just past 11. The lights come on behind you. You pull over. Your hands are on the wheel. Your documents are ready. The officer walks up, takes your license, looks at it, and then looks at you and says, "Have you been drinking tonight?" And almost every single driver in that situation says the same thing. "No, I haven't." Or some version of it. "No, not at all. Just water. I had 1 beer with dinner about 3 hours ago, but I'm completely fine." And they say it because it sounds like the right answer. Because it sounds like exactly what an innocent person says. Because silence feels suspicious, and they have nothing to hide, and they want this stop to be over in 2 minutes. Here is the problem. That question is not a formality. It is not routine courtesy. It is a legally structured tool, and every possible answer you give, including the ones that sound innocent, can be used to build something against you. Yes or no, admission or denial, confident or nervous. Every version of an answer hands the officer information he did not have before you spoke. And the one thing most drivers never consider is that they were never legally required to answer it at all. There is no law in this country that requires you to answer investigative questions during a traffic stop. The legal obligation at a traffic stop is narrow. You are required to identify yourself in most states. You are required to produce your license, registration, and proof of insurance. Beyond that, your right to remain silent is constitutionally protected under the Fifth Amendment. That protection does not start at the police station. It does not start at the moment of arrest. It exists from the first moment you are questioned by law enforcement, including through a car window on the side of a highway at 11 at night. Most drivers do not know that. And because they do not know it, they answer. And because they answer, the stop changes. Let me show you exactly how. There are 3 answers people give to the question, "Have you been drinking tonight?" And each one does a different kind of damage. The first one sounds like this. "No, I have not had anything to drink." It sounds clean, decisive. The kind of answer a completely sober person gives. But here is the problem with a flat denial. If the officer has any independent basis to suspect impairment, the way you were driving, your eyes, the smell of your car, anything, your denial becomes a contradiction to be tested. It does not close the investigation. It gives him a reason to pursue it harder. You said no, and now he is going to prove whether no is true. The denial did not protect you. It invited a challenge. The second answer sounds like this. "I had 1 drink with dinner, but that was hours ago. I'm completely fine." This one sounds responsible, measured, the kind of honest answer a reasonable adult gives to show they are not hiding anything. What it actually does is hand the officer a voluntary admission of alcohol consumption he did not have 1 second before you spoke. He no longer needs to establish whether alcohol was involved. You told him. He now has documented grounds to initiate a full DUI investigation regardless of whether there was any outward sign of impairment. You gave him permission to go further by trying to convince him you were fine. The third answer is the one that surprises people. It sounds like this. "I'm not going to answer that," said with attitude, said defensively, said in a way that feels confrontational or reactive. Even this answer, which is technically close to the right legal position, causes problems when it is delivered badly. Because tone and delivery matter in a roadside stop. Not because you are required to be warm, but because a confrontational refusal gives the officer behavioral signals he can document and use to justify extending the stop. The content of what you said might have been legally sound. The way you said it just made the next 10 minutes much harder. There is a right answer. And I want to tell you something about it before I give it to you, because understanding why it works is the part that makes you actually use it in the moment instead of freezing. A woman in Knoxville, Tennessee was stopped on Kingston Pike on a Saturday night for a broken tail light. She had not been drinking. She was stone cold sober, coming back from a late dinner with her sister. The officer walked up and asked if she had been drinking tonight. She said, "No, absolutely not." He said she smelled like alcohol. She insisted she had not had a thing. He asked her to step out. She argued. He escalated. She spent 2 hours on the side of that road, underwent field sobriety testing, and was eventually released without charge because she was, in fact, completely sober. But 2 hours of her night were gone, her car had been searched, and the entire escalation happened not because she was drunk, but because she argued rather than exercised a right she did not know she had. Her flat denial put her in a position she had to defend. Defending a position during a traffic stop is exactly the wrong place to be, because the stop is not a negotiation. It is not a debate. The moment you are arguing, you are losing ground, and what you are losing it to is your own words. Here is what you say. When an officer asks whether you have been drinking, or any variation of that question, including, "Where are you coming from? What were you doing tonight? How much have you had to drink? When did you last have alcohol?" Here is your answer. "Officer, I prefer not to answer questions." That is it. 7 words. Calm. Flat. Respectful in tone. No edge. No constitutional lecture. No explanation of why. Just 7 words delivered the way you would give your name to someone who asked for it. No drama. No apology. No addition afterward. If you are watching this and thinking that sounds hard to actually say out loud in the moment, you are right. And that is exactly why most people do not say it. Because the pressure is real. Because an officer in uniform with a flashlight in your face is not a theoretical situation, it is an immediate one. And your instinct is to resolve it by talking. That instinct is what these questions are designed to trigger. If you are new to this channel, and this is the first time you are hearing any of this, subscribe now. Every week we go through exactly these moments in detail. The questions, the pressure points, the legal rights, and the words that actually protect you. What you do not know can cost you in ways that follow you for years. The subscribe button is right there, and this information is free. Now let us look at what those 7 words actually do when you say them at a real stop. Because this is not just about the words themselves. It is about the legal architecture they create around you the moment they leave your mouth. When you clearly and calmly decline to answer investigative questions, you accomplish several things at once. You remove the officer's ability to use your words as the basis for escalation. You cannot be caught in an inconsistency if you have said nothing. You cannot give a nervous answer that reads as deceptive if you have given no answer. You cannot introduce a subject, alcohol, prior location, recent activity, that was not already established by independent evidence. The silence does not convict you of anything, but the words might. Beyond that, you put something on the record. If this stop becomes a legal matter, if there is an arrest, a charge, a court date, your calm, polite invocation of your right to remain silent looks very different in a report than 5 minutes of stumbling, contradicting yourself, and trying to explain why you mentioned the bar you did not go to. Lawyers reading that report will know exactly what happened and why. And what happened is almost always the same thing. The driver talked. Here is what most people get wrong about this in practice. They think staying silent will make the officer more suspicious. They think it will make the stop longer. They think it signals guilt. None of those things are true as a matter of law. And statistically, they are not even reliably true in practice. A calm refusal to answer investigative questions gives an officer less to work with, not more. Without behavioral escalation, without admission, without contradiction, and without voluntary disclosure, most stops proceed exactly as they should. The officer checks your documents, runs your plates, and resolves the stop based on the actual reason he pulled you over. Now, some officers push back. And this is the moment that separates drivers who hold their position from drivers who give it up. The pushback sounds like one of a few things. I'm just asking a simple question. If you are not drinking, you have nothing to worry about. I can make this a lot longer if you want. And in that moment, almost every driver who knew the right answer caves. Because the pressure is real, and because they have not thought through what comes next. Here is what comes next. Nothing changes. Your response is the same. With respect, officer, I'm exercising my Fifth Amendment right to remain silent. You say it with the same flatness, the same absence of drama. You do not explain it further. You do not justify it. You do not soften it with, I just do not want any trouble. Because the moment you add that, you have re-entered a conversation you chose not to have. An officer cannot lawfully detain you indefinitely because you decline to answer investigative questions. If he has independent probable cause to continue, he will. If he does not, the stop ends. That is not a loophole. That is the law. And staying calm, staying quiet, and staying consistent throughout that exchange is the thing that makes that law work in your favor rather than on paper, where it cannot help you. A man was driving northbound on US 19 outside of Clearwater, Florida at about 12:30 in the morning. Stopped for a wide turn. The officer walked up and asked if he had been drinking. He said he had not, but he had just left a work event and there may have been wine there. He was not sure if he had had any. One sentence. That one sentence, uncertain, trying to be transparent, trying to sound reasonable, gave the officer everything he needed. There had been alcohol. He was not sure how much. He was coming from an event where alcohol was present. 40 minutes later, he was completing field sobriety exercises under highway lights for a stop that started over a wide turn. He blew a 0.04. Half the legal limit. No charge. But a 40-minute investigation, a car left on the side of a highway, and a ride home from a stranger because his wife was already asleep. All of it avoidable. 7 words. That is the cost of not knowing them. Let us talk about the phrases that end otherwise clean stops badly. Not because they sound dangerous, but because they sound exactly like what an innocent person would say. The first one is, I only had 1 or 2, but I'm completely fine to drive. People say this because they think measured honesty is better than silence. They think an officer respects the driver who tells the truth and is reasonable about it. What they are actually doing is providing a voluntary admission of alcohol consumption, establishing that alcohol is a subject of relevance in this stop, and inviting a full impairment investigation before the officer had a single lawful basis to initiate one. The stop was about a wide turn. Now it is about something else. You changed it. He did not. The second phrase is, "You can search the car if you want. I have nothing to hide." People say this because they think it sounds cooperative. They think a clean search ends the stop and sends them home faster. What it actually does is provide consent to search. The officer no longer needs probable cause, reasonable suspicion, or a warrant. You gave him permission. And consent is not revocable once it has been given and acted upon. Whatever is found in that vehicle, whatever you forgot about, whatever looks different from what it is, whatever belongs to whoever borrowed your car last week, is now a lawful discovery because you invited the search. There was a driver stopped outside of Charlotte, North Carolina on a Sunday evening for running a yellow light that had turned red. He said, "Go ahead." The officer found a utility knife in the back seat that the driver had used for moving boxes 6 weeks earlier and completely forgotten about. In that county, in that moment, with that officer, that knife became the basis for a 2-hour detainment and an arrest that took 8 months and significant legal fees to resolve. A knife that he owned, that he had forgotten about, because he said 2 words he was never required to say. So here is where this lands. When an officer asks if you have been drinking tonight, or any question that goes beyond your identification obligation, your answer is 7 words. "Officer, I prefer not to answer questions." Calm once, nothing added after it. Hand your documents when asked. Maintain eye contact. Say nothing else. If he pushes back, you have 5 more words. "I'm invoking my right to silence." You do not raise your voice. You do not explain yourself. You do not give the impression that your silence is fear. It is a right. Exercise it the way you would any other right, quietly, confidently, and without apology. What staying composed through all of that does is take away the behavioral grounds for escalation. You are not emotional. You are not combative. You have said nothing that ends up in a report working against you. You are a driver who knows the law and is operating within it, clearly, calmly, and without drama. That is not suspicious. That is your right. The next video on this channel covers what happens right after this exchange. You have said the right thing. You have handed your documents over. The officer has run your plates. And then, instead of saying "have a good night," he looks back at you and says, "I need you to step out of the vehicle." And everything changes in 1 second. Do you have to step out? What do you say? What happens to everything you just protected inside that car? The answer is not what most people think. If this is the first video of ours you have watched and any part of this felt like something you should have known before your last stop, before the night you answered every question and hoped nothing would come of it, subscribe now. This channel is built for exactly that. Every week, one more situation, one more question, one more moment where knowing the right answer is the only thing standing between you and something that follows you for months or years. Your rights exist whether you know them or not, but they only protect you when you use them. Subscribe and make sure you know them before you need them.